first case to come before the court is State versus Brantley. And each side will have 15 minutes to present their arguments. And obviously, Mr. Hirsch, you can reserve up to 5 minutes if you so desire.
Thank you, Judge. Good morning, Judge Carr, Judge Moore, Judge Schaefer. As this court is aware, I'm counsel for the appellant, Derrick Brantley, in this case, which has received a bit of attention due to the nature of the offenses. We have raised a number of assignments of error. I would address what we designated as assignment of error 1, and we are asserting that Mr. Brantley's right to a fair trial was violated when the state engaged in prosecutorial misconduct by not disclosing material witnesses had entered into plea agreements. We have asked this court to take judicial notice. If you look at the sequence of this, the co-defendant to Mr. Brantley was tried after Mr. Brantley, and during the course of his prosecution, it came out that 2 material witnesses, Deontay Woods and Anthony Townsend, had received some kind of beneficial treatment from the prosecutor's office.
How's that in the record before us?
Your Honor, we have attempted to put it into the record by referencing the reporting that occurred in local media. I recognize that there was nothing indicated during the course of Mr. Brantley's trial with regard to this treatment that was being given to these 2 witnesses. But I think in view of the public attention and the media coverage of this case, that it cannot be overlooked.
Well, I'm not suggesting that it be overlooked. It's just we have to overturn, I don't know how many decades of jurisprudence in order to consider something that may have been reported in the media that was not record evidence that would form the basis of the factual basis of the assignment of error that you have brought to our attention. Wouldn't this be more appropriately brought before us in post-conviction relief where you could, or someone, you could obtain an affidavit that put those facts before this court, or before the lower court?
Again, if we look at the sequence, we had Mr. Brantley's trial. We had the, and again, this court may be aware that there were 3 different occasions when a jury was brought together relating to the co-defendant in great part because of this information that these material witnesses were, one of them was walked down the hall virtually after his testimony and taken into a courtroom in order to get the special treatment that had apparently been promised to him. Mr. Brantley, and this wasn't disclosed with regard to the co-defendant until it came about by the knowledge of counsel. And it certainly wasn't going to be disclosed during the trial of Mr. Brantley. I think that certainly issues of due process are paramount. We have as attorneys, we have a responsibility. At this point, there has never been any acknowledgement of the special treatment, although, again, this court may be aware that the Summit County Prosecutor's Office, in fact, stepped away and sought the assistance of the Cuyahoga County Prosecutor's Office because of their concern about, I would call it impropriety.
Is there a motion? And I know this may not be in our appellate record either as far as that goes, but is there a motion for a new trial in Mr. Brantley's case?
Your Honor,
Excuse me.
yes.
I apologize for
Judge,
that.
I am not aware, I am not aware. I may have looked that up at some point to see if his trial counsel had requested a new trial. To tell you at this moment,
That's fine. The only reason I was just kind of telling Judge Moore about the appropriate remedy here, and that seems like that might be something like newly discovered evidence or whatever that wasn't available to Mr. Brantley during trial, if all that is the case.
it would seem that as officers of the court, that whether it would be defense or prosecution, that there would be a responsibility to disclose, even after the fact, that these witnesses had received some level of preferential treatment. I can indicate that the state of Ohio has raised exactly the issues that you have alerted, that perhaps this would be something that would be taken up under post-conviction relief. But there was a contemporaneous aspect to these two cases involving Mr. Brantley and the co-defendant. And it was not that long after Mr. Brantley's trial and conviction that this had come into the awareness of counsel for the co-defendant and, for that matter, counsel for Mr. Brantley. We have other errors that we have raised, and one of them would be the insufficiency of the evidence. We would indicate that in our analysis, but for the testimony of Mr. Woods and Mr. Townsend, this case may not have unfolded as it did. We are not disputing the deaths of the four individuals who are at the center of the case. But you have witnesses who are testifying, and in our opinion, if those witnesses had not testified, it certainly would have put forth a different level of evidence. We would submit as well that the verdicts in this case were against the manifest weight of the evidence in view again of the testimony of Mr. Woods and Mr. Townsend. We would also indicate that we believe that the trial court erred in not suppressing statements that were made by Mr. Brantley. If you have recollection of the transcript, which is several thousand pages, early on in the trial, there was presentation of considerable photographic evidence. There were apparently friends and family members within the courtroom, and it appears at some point that the judge called a recess and removed the jury from the courtroom, and at least took some steps to try to mitigate the disruption in the emotion of that setting. There were objections by defense counsel. It seems as well that in view of the graphic nature of the photographs, in view of the technology which puts them up on a large screen, I believe that the transcript indicated that the state of Ohio had attempted to shift the direction of the screen in order that individuals in the gallery wouldn't perhaps be affected by what was presented, but the transcript shows that there was quite a bit of consternation, and we would submit that this impacted Mr. Brantley's right to a fair trial.
I don't recall in your appellate brief whether you indicated what the trial court said in terms of giving instructions. But that would certainly help us in determining whether or not it was a sufficient curative instruction. Do you have any recollection of what the court said?
I believe that I have the transcript.
I don't want to take time.
Judge, I respect that. Yes.
Well, we'll read the transcript.
The court attempted, I believe, a curative instruction in order to remedy what had occurred, but it is apparent, even from reading the written words, that it had a striking early effect on the character of this particular trial.
Counsel, you're at 4 minutes, you want to stay some time?
Your Honor, I can conclude. I think I've touched on the issues now, and I will hear what the state says. I may not come back up.
Thank you.
May it please the court, counsel, I'm Heaven DiMartino on behalf of the state of Ohio, the appellee. We are asking that this court affirm Mr. Brantley's convictions in this case. With regard to the first assignment of error, as I indicated in my brief motion, the allegations that are set forth in that first assignment of error are not in the record in this case, and they're not supported by the record even in Mr. Haywood's case, which this court can't consider because it's not before it. But basically, in Mr. Brantley's case, his trial concluded. He was sentenced. There was no issue with regard to these two defendants, the two co-defendants at issue that testified are Townsend and Woods. Their testimony, you can't argue that if they had not testified that the evidence would be against, the manifest weight, or it would be insufficient. The fact that there may have been a failure to disclose some type of a deal, which the state is not conceding that there was any type of misconduct. There's no finding of misconduct. The defendant has not presented this court with any judicial statement that says that the prosecutor's office engaged in misconduct, and I would represent that there is no such finding of misconduct. Yes, Mr. Haywood got another trial. That was by agreement, but not based on quote-unquote prosecutorial misconduct. The idea of allowing this court to overturn decades of jurisprudence based on an article in the Akron Beacon Journal where a reporter characterizes something in a way that they choose to is frightening. There's nothing in the record. It's certainly an Akron Beacon Journal article should not be enough. That's not based on what happened in court or any judicial decision. It's based on the reporter's interpretation. Again,
and I understand that completely, but I guess it would be troubling to the court if the same people testified in both cases, the same murders, and one co-defendant got a new trial based on a failure to disclose information that obviously the prosecution and the defense felt was necessary to give that person a new trial,
right, the new trial wasn't. If you look in the record for Mr. Haywood, which of course is not before the court, there's no finding, there's no order that says Mr. Haywood's getting a new trial because of this misconduct with failure to disclose. Yes, there were issues in that trial. There was a motion for, there was a new judge, and there were several other motions, but there's no journal entry that says Mr. Haywood is getting a new trial because there was misconduct based on some failure to disclose. Those were issues that were raised by the defense. There was discussion with the state. There's an agreement to have a new trial, but it's not based on, that per se. And
Go ahead.
Those two co-defendants did testify in Mr. Haywood's new trial. So even if he had raised this issue, the remedy would not be that Townsend and Woods are not permitted to testify. The issue would be that there would be additional questioning permitted as to the quote-unquote deal, which there's no evidence in this record about. And the correct remedy would be to file a motion for a new trial based on new evidence and/or post-conviction relief. I understand that the way that it's presented in the brief, especially if you look at it, it sounds awful, like there is some due process violation, but it's not supported by this record, nor is it supported by Haywood's record. And the rules of procedure don't allow for this remedy for it. So while I understand where Mr. Hicks is coming from, and I understand how this court would be concerned if it were true as presented, but that's not the way that it is. And as an officer of the court, I can tell you based on my involvement that it is my understanding, and I've never seen a journal entry to the contrary, and I know that it doesn't exist, that there was a finding of prosecutorial misconduct. There just wasn't. There could have been some type of error, but it was not misconduct. And in fact, if you do look at Haywood's case, he did get another trial, and he did have the same two defendants. They still testified to those Woods. With regard to the issue with the weight of the evidence, Mr. Townsend and Mr. Woods, their testimony puts Mr. Brantley and Mr. Haywood both at the scene.
But before you go into that, I want you to say that thought. But I don't think you're suggesting that let's assume that there was an agreement.
Okay.
I don't think you're suggesting that may not have made a difference in Mr. Brantley's case with so much of the credibility of these two witnesses being a part of the state's case. You're not suggesting.
Well, it would hinge on what's the deal. What was the deal? And I don't know that there was ever a deal.
Well, let's just assume for purposes of argument that there was a deal, that they got some favorable treatment.
And then the witness testified, I didn't get any.
Right.
You would have to have all those things in place.
And then the witness testified, as Mr. Hicks pointed out in the record, no, I didn't get anything.
Right.
Then it's open season on the credibility on all, basically everything they testified.
I would agree if that was the scenario that went forth, but it would still not be proper to raise it on direct appeal when that's not in the record. So certainly if someone got a deal, a true deal, and they testified that they didn't, and then that left the jury with the misperception as to what the credibility of the witness was, no, I'm not suggesting that would not affect at least the jury's ability to determine credibility. I'm just saying that, one, that's not the way that it happened, but more importantly, it's not in this record. So this court should not consider it. When you have the testimony of those two witnesses, that does put both Brantley and Haywood at the scene. It puts them talking about killing people and taking it to the grave, etc. There are text messages between the two, a 1 o'clock phone call, a 1 o'clock text to Mr. Roberts, one of the decedents, and then 2:10 a.m. text from Brantley, Haywood to Brantley talking about killing people, 2:48 talking about how they're going to kill somebody and get all the stuff. There was a testimony that there was a heroin deal that went down at that house that day. And then Mr. Haywood's phone was wiped clean, which is evidence that there was a reason why he did that. With regard to the Miranda violation that was alleged, Mr. Brantley had come to the police station independently to try to bail Mr. Haywood out on a separate case, and while he was there, the police asked to talk to him. He consented. There's a video of him consenting. So he was not in custody, and he was also given Miranda, so there's no issue there. With regard to the pictures, this was a particularly gruesome case. We had 4 victims, aggravated murder charges, capital specification, capital case specification, death spec. The idea that one picture would have been enough for the state to introduce to prove 4 murders, how they occurred, the cause of death, the manner of death, that the medical examiner presented, I believe it was 132 pictures or so in a PowerPoint to explain what happened to each of these 4 victims. that was necessary due to the number of victims in this case. We have an obligation, obviously, to prove beyond a reasonable doubt what happened. So while Mr. Brantley is not disputing that there were 4 people who died that day, the state still had to prove how they died, the manner they died. We had elements that we had to show. So certainly this crime scene and the pictures were unpleasant. I would argue that the pictures, to the best that the state could crop them and judiciously selected the pictures that were necessary, that the pictures weren't gruesome, and even if this court was to find that they were gruesome, the probative value is outweighed by the prejudice to the defendant. We had elements we had to prove, and we had to do that. With regard to the
Can you go back just for a moment
Sure.
to the number of the photos? There's one reference to an exhibit that had, I don't know, 150 some pictures. We'll have an opportunity to look at those pictures, but are you satisfied, having reviewed the record, that within that number there are not photographs that are repetitive? In other words, of the same scene,
right.
maybe closer up or further away. Are you
Right.
satisfied?
I am satisfied with that, I am. And, sometimes there has to be close-ups and everything else for the medical examiner to explain the injuries and all that. So sometimes it's necessary. I don't believe that there are any unduly repetitive. The state did take extraordinary effort, in my opinion, to narrow down the number of pictures and to crop out things in the picture to limit the effect on the jury. With regard to the reaction in the courtroom, the record shows that the court and the prosecutor took every effort to warn people in the gallery and the jury that the photos were coming, that they were going to be, I think the court might have used the word gruesome to describe it, but just to kind of give the people an idea of what was coming. There was some reaction, but there was also a curative instruction that was given. It's to be presumed that the jury followed the court's instruction, that they're not to consider any reaction by the gallery when they decide the guilt of this defendant. So I would argue that in this case, the record shows that the court and the prosecutor both made an effort prior to the demonstration of the photos, and that the court made the proper curative instruction following the pictures, and that there's no indication that this jury disregarded the court's instruction and gave those pictures and or the outburst any weight that it was not within their purview to do.
I just want to make sure the court gave the jury curative instructions in regard to the photographs, but also gave a curative instruction in regard to the reaction that they
Correct.
did.
Correct.
That they obviously witnessed.
Correct.
Do you remember Judge Moore asked Judge Hicks?
I didn't bring the like 3,000 pages with me, and I didn't bring my iPad. So sometimes I do, but I didn't today, and I don't have. I didn't.
That's all right.
But I recall the instruction being fine. I just don't recall exactly what it was, so I apologize for that. If there are no other questions, we would ask this court to affirm Mr. Brantley's convictions. Again, noting that the proper remedy for the first assignment of error would be a motion for post-conviction relief or a motion for a new trial. We would ask this court to affirm.
Thank you. You do have 3.5 minutes, it's up to you.
Although it is not in the record, it does appear on its face that there was a failure of the state to disclose that the deal had been arranged between the state of Ohio and these two material witnesses. There is nothing in the record because of the state's shortcoming in disclosing it. We would indicate that at all times the state had a responsibility to make this disclosure, and that courts are about fundamental fairness and due process. And those are the issues that really make a foundation for our system. Judges, we thank you for listening to our argument.
Thank you. The court, as you know, will take the matter under advisement, and we will issue a written opinion that will be sent to both sides, and we also release our cases electronically on our website and the Supreme Court website. So thank you very much for your presentation to the court.